Good evening and welcome to the 8th event of the lecture series Encounters, New Perspectives on Asia, America and Europe, a joint initiative of the Center for Asian and Transcultural Studies and the Heidelberg Center for American Studies. My name is Welf Werner. I'm the director of the HCA. The CATS and the HCA launched this series in the fall of 2021 to focus on the relationship of the two superpowers of the 21st century, the United States of America and the People's Republic of China, a relationship that has become increasingly contentious. China's growing self-confidence is a challenge for the US and its allies alike, and thus also embroils Europe in this new trans-Pacific geopolitical rivalry. We are convinced that we need to improve our understanding of the two nations that will shape the world in the decades to come. Tonight we will once more turn our attention to Taiwan and especially to the legal basis that frames the relationship between the US and China and Taiwan. After a year and a half, we are looking back on more than half a dozen exciting events that have contributed to an informed debate on one of the most imminent challenges for Germany and Europe. If you missed one or the other, you can catch up in the video section of the HCA website. After a number of online dialogues and a couple of conversations that took place in the great lecture hall of the CATS, it is a pleasure that Encounters is taking place in the HCA atrium today for the first time. My collaborator in this project, Barbara Mittler, will now introduce tonight's guests. Please allow me to already extend a warm welcome to you, Barbara, and to Ian-tsing Dieu and Hanno Kube. Thank you.
Good evening from me as well, and I also want to just say a few words why this Encounters is taking place today on this particular topic. In this contentious relationship between the United States and China, there is one object of contention, and Taiwan is that object. And so obviously we need to take that into consideration. And especially in the past few months, of course, and especially since the beginning of the war in Ukraine, Taiwan has become a clear focus for European and German politics. Taiwan's thriving democracy, which has evolved since the late 1980s, is built on two pillars. And these two pillars, again, are Germany and the United States. And there we are back to Encounters. First, and somewhat counterintuitively, perhaps for the Germans among us, the Weimar Constitution becomes the most important building block for what later becomes the constitutions of the Republic of China, not the People's Republic, but the Republic of China, which comes into being in the late 1940s, as drafted in 1946. Built on a couple of preliminary constitutions that have been fluctuating, not really in use since 1912. And it's this legal order, Weimar Constitution based, which forms a sort of firm basis for what has become one of the best democracies in the world, in Taiwan. Secondly, the Taiwan Relations Act, a 1979 act, which follows the disengagement of Taiwan as representative of China in the United Nations, which takes place in 1971-72, right? Then you have the Nixon visit in China, and then basically you have the entire world going from thinking that China is Chiang Kai-shek and Taiwan to thinking China is Mao Zedong and the other part of the Taiwan Straits, right? And so our two speakers today, or basically our dialogue partners today, will address this question of what happens after the Taiwan Relations Act, or what happens because the Taiwan Relations Act of 1979 guarantees, in spite of this new sort of world order, that the US is somehow safeguarding Taiwan, but not somehow, but not really clear how. And especially, I think legally, it's not quite clear how. Anyway, so who's speaking? We have Zhao Yanqing, born in Taichung, that is the southern part of Taiwan, Director General at the Taipei representation in the Federal Republic of Germany in Munich. So that's what you have when you're no longer, can no longer have a consulate office. That is the Taipei representation. He has initially studied engineering and then was inspired by the democracy movement in Taiwan and the Legal Council for Political Dissidents in Taiwan, which then sort of made him very interested in studying law. And so he did at Zhengzhou University in Taiwan and then in Heidelberg and in Freiburg in Germany. He worked at the Max Planck Institute for International Criminal Law and Criminology in Freiburg as the lecturer at the law faculty of Jungye and Christian University in Taiwan, then as an assistant professor at Chinese Culture University. And finally, he was a Deputy Director General in the Department of Legal Affairs at the Ministry of Foreign Affairs and later the National Security Council of the Republic of China, Taiwan. He has had very important research stays at the Center on Democracy Development and the Rule of Law at Stanford University, and then at the Executive Education Program at Harvard Kennedy School. And finally, he was also a visiting scholar at the George Washington University in the US. So you can see Taiwan and the US is in the name of Dr. Zhao clearly related. The second person on the podium is Hanno Kube, who is director of the Institute for Public Finance and Tax Law at Heidelberg University, holds the chair for public law with a special focus on public finance and tax law. That is the Lehrstuhl Öffentliches Recht, Finanz- und Steuerrecht. And he too studied law at Heidelberg University, maybe even at the same time, or roughly at the same time. He also studied at the University of Geneva and at Cornell. He obtained his doctorate and habilitation in Heidelberg, then worked as a professor at the universities in Eichstätt, Ingolstadt, another thing they shared, something Catholic in both of your university careers, and at Mainz. Coming from questions of ecology and law in his dissertation, which was a dissertation entitled Eigentum an Naturgütern, Zuordnung und Unverfügbarkeit, Schriften zum Umweltrecht. Since his habilitation, he has focused his shift to constitutional European law, public finance law, and German, European, and international tax law. He's co-editor of a handbook on constitutional law, a commentary on income tax law, and the tax law journal Steuer und Wirtschaft, which I'm sure many of us should read and many of you do read. He acts as representative before the Federal Constitutional Court, the Federal Administrative Court, and the Court of Justice of the European Union. And not unlike Dr. Zhao, he's been guest researcher in several universities in Europe and the United States. That is the European University Institute in Florence, the University of California at Berkeley, again, one at Stanford, the other at the University of California at Berkeley. Enemies, but anyway, close. And then Cornell University, and finally National Taiwan University, which is why we invited him to be in conversation with Dr. Zhao. So have a good conversation, nice evening, enjoy, and I'm looking forward to what we're going to hear.
Yeah, thank you, Barbara, for the nice introduction, and thank you very much for inviting me here to this event. And especially, I feel really honored, especially after 25 years back to Heidelberg University. And it was quite emotional as I see the plaque outside the Hauptstraße and think, oh, it's really a moment for me. But actually, I want to share with you today with two questions. The first, actually, Taiwan we always say about Taiwan question, but I think Taiwan provide the answers, not the question. And secondly, and the existence of Taiwan is not, is actually is quite a miracle actually. And you can look back in the 1970s. That times the international societies has already written of Taiwan as a member of international society. That is why we are still fighting for our statehood till now. But what is the secret for Taiwan's survival? Actually, I would say, if in one word, is democracy. A longer sentence is that Taiwan's society is integrated into the rule-based international order after 1987, as Taiwan's just started the democratization process. And if you know about the history of Taiwan, Taiwan has the longest martial law enacted for 40 years, from 1947 to 1987. So that time, even one topic today we will touch on is about the adoption of German Weimar Constitution. But actually, the Constitution of Republic of China in 1946 have never been enacted in Taiwan or in mainland China because of the civil wars just right after. And after the long history of martial law, as I mentioned, why the international society has written of Taiwan as an international member is that in the 1970s, actually, there were not so many differences between Taiwan and mainland China. Both countries were governed by one-party regimes, and there's governmental skills are quite similar, and to suppression of political dissidents, and also to suppress the human rights. And at times, there are not big difference between both sides across the Taiwan Strait. When it's not insubstantial, it's only the difference is only the intensity of suppression. So that's why in the 1970s, as Taiwan was kept out from the United Nations and severed their diplomatic relations with the U.S. in 1979. The conventional understanding in the international society is that for the long run, Taiwan will be swallowed up by China. And also in Taiwan, this sensitiveness is always there till now, because you can see for the inhabitants, mainland China is 65. Okay, I'm sorry, I have to switch from German to English. And also from this balance of power is so imbalanced, so nobody really expect there will be some peaceful solution like there's two Germany solution back then. So what is then the survival strategy for Taiwan? Is then even then's ruled party Kuomintang has understand that Taiwan has to start this democratization process. That means we have to really enact the rule of law in our society. And fortunately, we have these traditions for adoption of the German legal culture. And it's a part of back to our colonial times from 1895 to 1945 under Japanese colonial rules. And as you know, Japan has originally adopted Code Napoleon, the French legal system, but after the German-Franco's war, and they decided to switch to German system. So it's always very difficult to understand the Japanese legal system because some is about this French legal concept, some is German legal concept. It's all mixed. But in the Republic of China times, also started this modernization process to adopt it, the Western law. First, it's about the German's criminal code. And then Taiwan, Republic of China has adopted the Swiss civil code because that time it was a little bit moderner than the German one. And also in Switzerland, there are no this separation between the normal civilians and there's commerce people in the Swiss model. So that's why this tradition is already started in the early 20th century. But as I mentioned, the turning point is in the late 1970s when Taiwan's have this existential threat from the international society. So that time, from the government and from the civil society have started this process to want to get integrated into the international community. So our democratization is not from purely domestic politics or consideration. It's also this existential threat from outside world. But the people will ask, and in why we can in less than 40 years from an autocratic system into a vibrant democracy. And this is always I want to share with the German public is that it's because of this German legal culture. And I think if you study Chinese, know about the Chinese culture, you will know that the Chinese language is not a language for discussion. It's not a language to understand there's a conflict of interest because it's so ambiguous. And just for the grammar's sake, I always want to explain, like my wife is learning German now. She was asking me why the German grammar is so complicated. I say, because you have to explain everything correctly in German. Like my wife asked me, with whom are you going out this evening? And in Chinese, I would say, with somebody. But in German, you have to identify. It's female friend, male friends, a close friend, or a lover. So it's no way that you can escape this explanatory necessity. But in Chinese, it's very easy. When you ask the Chinese politicians whether there was massacres in the Tiananmen Square, he will say, no, today there were no people died there. In Chinese, it was totally correct if he answered, there are no people died. Because in Chinese, there are no these tense. You cannot really identify what he's lying or telling the truth. So it's the problem in our Chinese culture. So with the adoption of this German legal culture, actually it's a kind of process for Taiwanese society to think some things more clearly and to identify the conflict of interest. And it's also for my amaze as I enter the first semester law school study in Taiwan, our textbook is always writing in Chinese and clamor with the German's legal concept. Tatbestandsmäßigkeit. You know, for an 18 years old Taiwanese, it's so complicated. But through this transform, with this German legal culture, is actually is the basis for our creation of a democratic atmosphere in the society. So today's Taiwan is the only Asian country legalized the same-sex marriage, and actually it's not a very easy step. It is through the year-long discussion, and I know here there are experts about the Weimar Constitution. So today I want this is not to discuss this perspective too much, but maybe two features I should mention. First is this in the Weimar Constitution to set up this Gewaltenteilung, to set up this separation of power between the president and the premier. And it's very important issues for Taiwan's democracy. And because Taiwan's president is directly elected, but the president has a right to nominate the premier. And from this separation of the power have to quite effectively prevent another dictatorship to happen in Taiwan. And we are not looking, because president can have all the critics but still we have a functioning government in the executive branch. So this power separations, I mean, is different from the French model. It's just adopted from the Weimar Constitution. It's also the main point why that time back to 1946, why in Republic of China had chosen the Weimar Constitution model. And the second one is in the Weimar Constitution has stipulated the guarantee of social rights. And this is another important issues for Taiwan's democracy. And especially if you understand that Taiwan has enacted our universal health insurance in 1996. Actually, that time was according to the German model. And that time we have purchased this chip card from Germany for our insurance. And so it's the two features what really provide the most important fundamentals basis for Taiwan's democratization. And I can also mention another few examples. One is that there are not so many research in Taiwan about the influence of a German's legal system in Taiwan. But only one I can find is about how our Constitution Court cited the foreign decisions. And from 2003 to 2010, in the 7 years, there are 460 decisions from the Constitution Court in Taiwan. They have cited the foreign resources. And between land, 260 times has cited the German decisions. It's well beyond the half. And also the other aspect is our criminal code reform in the early 1990s. It's just because that times you should understand criminal code was always or is always known in Chinese culture as a separations tool to against this freedom of expression. As you can see the example in Hong Kong about the national security law, and it's not, actually it's quite familiar to us because before 1990s, we had the same provisions in Taiwan. But through these abolitions of such crimes had to protect Taiwan's freedom of expression, and that time it was actually led by two German-trained professors. And for their effort, actually, Taiwan can now enjoy the freedom of expression, and it's also very important features. And now, at the very beginnings, I have mentioned why Taiwan is the answer and not the question, because we should understand there's after the Second World War, the whole international order is built on the rule-based regulations, and it means actually we need to respect the basic right, and also to respect the self-determination right for every nation. And such features, how can it transfer to Taiwan's effort for the struggle of his existence? Actually, we should understand nowadays international conflict is really about systemic competition. We have to understand it's a competition between democracy and autocracy. And if you understand that, then I can, and that's why I can say that Taiwan is the answer. Because through this democracy, not only secure our national security, also provide our opportunity to strive economically. And here, everybody actually is, in Germany, many are discussing about Taiwan's semiconductor industry. And this industry is especially developed in such kind of international order. Because in semiconductor industries, it means you need an open innovation. It means there's a whole, the invention, all the innovation should be guaranteed by an international legal order, which respected by those participants. And that's also the reason why China has invested over $1,000 billion alone in the next year, but they cannot achieve to build up in this industry. And that's why, and through this democratization process, also bring Taiwan to integrate it into this international order. And now I will come to my second topic about why the American guarantee is so important. Actually, if we see, it's not only for Taiwan's survival. Actually, after the Second World War, in West Europe, in Japan, in South Korea, in Taiwan, in Philippines, it was guaranteed actually by these two features. First is the rules-based international order. It's what I mentioned. Actually, domestically, is the rule of law. And the second feature is guaranteed by Americans' security commitment. We have to understand that even at this moment, because even Taiwan, we have free riding for this American guarantee for the past decades. Even nobody understands that when Taiwan is recognized by the U.S., why Taiwan is still under this umbrella of the American security guarantee. So we have to back to some legal issues, to the 1979 Taiwan Relations Act. In this Taiwan Relations Act, if you read closely to this act, there are two things. The American provide Taiwan the guarantees. First is that in this act has guarantees Taiwan's right of self-determination according to international law. And the language it used in the Taiwan Relations Act is the same in the UN charters, in this International Convention for Human Rights. But in UN Charter or in the ICCPR, they have mentioned the political rights, but it was taken out in the Taiwan Relations Act. It means it just guarantees Taiwan's cultural, societal, and economic rights of self-determination. But if you read about that, you can see it's a compromise. But the second feature is that in this act, the U.S. has obligated to provide Taiwan there's enough arms for self-defense. And this features is, if you read about in this act, it's quite tricky, because when in this act talking about this guarantee of right of self-determination, it will say it's the relationship between the American and Taiwanese people. But about there's arms sales obligation is said about is the relationship between America and Taiwan, because on the end, the American cannot sell arms to Taiwanese people. So it's this government-to-government relationship in the Taiwan Relations Act. But I say it's really tricky because in the Chinese, in the official translation of the American State Department, they have translated even in the arms sales, it's saying in Chinese saying it's the guarantee the arms sales from the American people to Taiwanese people. Because they don't want to have some, maybe next time they hope that in the PRC they don't understand English. Yeah. But it's not, but back to this histories, maybe I have speak a little bit too long, but I'll finish. I'm trying to finish in 5 minutes. Yeah. But back to the background of the Taiwan Relations Act is that it's a totally congressional initiative, because that time when the Carter government severed the diplomatic tie with Taiwan, they just think, as I mentioned, with this sentiment that Taiwan will be swallowed up by China in the next few decades. So actually, President Carter has not provided any security guarantee to Taiwan. But for the American Congress, they think there's a moral or there's some kinds of other motivation, so they enacted this Taiwan Relations Act to provide Taiwan this security guarantee. And especially about these arms sales. According to Americans' Arms Export Control Act, the American government can only sell or lease weapons to foreign countries or international organizations. As America has ceased the diplomatic ties with Taiwan, now is the problem whether Taiwan is eligible to buy arms from the U.S. if it's, as the PRC has always mentioned, according to the One China policy, Taiwan is part of China. And actually, the US has no right to sell arms to Taiwan. It's like from the Freistaat Bayern. The Free State Bavaria cannot buy weapons from the American government. It's obviously, if it's really governed this One China policy. So it's a necessity for the U.S. Congress to find a legal basis to give Taiwan some kind of this is security guarantee. And afterwards, China feel they are kind of they think they didn't understand there's the power relationship between in the American government. So that times the Chinese government has raised their protest against the Taiwan Relations Act. So China and U.S. government has started the negotiation. And the result is the 1982 so-called August 17 communique. In this communique, and for the Chinese, they think the U.S. has committed to cease the arms sales to Taiwan. So with the from time to time to decrease the arms sales and to zero is the Chinese understanding. But for the American understanding is different. But till 2019, almost 40 years later, actually nobody really know what is really behind this communique. And actually it's on September 10, 2019, as the former American National Security Advisor, John Bolton, left his office one day before, he has declassified a so-called Reagan Memorandum. That time, President Ronald Reagan has issued a presidential directive to explicitly explain what is the U.S. position for the arms sales to Taiwan. And at this point, I think yesterday I just heard a podcast and also a news from China. It's about a song is criticizing the Chinese government. And I'm amazed because it's normally it's not happening in China. And it's mentioned to president, especially important for the history. Both are actors. One is Ronald Reagan, and the other one is Zelensky. And these two actors become president. One has ended the Cold War, and the other actually have also saved Taiwan. Actually, if the Ukraine didn't defend itself bravely, actually Taiwan is nowadays also in quite dangerous situation. And back to this Reagan Memorandum, it has explicitly mentioned the quantity and quality of the arms provided Taiwan be conditioned entirely on the threat posed by the PRC. And for the legal analysis, I will just mention a few points from my point of view. First, actually, after these negotiations, China has recognized the right of the U.S. to sell arms to Taiwan. And this arms sales is not an internal affair of China. Otherwise, they don't need to negotiate with the U.S. And the second point is Taiwan and PRC are definitely two separate international legal entities. As I mentioned, arms sales is to a domestic government is just an explicit violation of international law. And also in the August 17th communique, China has committed to a peaceful solution to the question of Taiwan. And the next point is that the U.S. have committed to maintaining Taiwan's essential defense capabilities. And this guarantee actually is also stipulated in the UN Charter to maintaining the regional peace. So that's why now come to my conclusion. Actually, after Second World War, world order is really, like I mentioned, it's built on two blocks. One is the rules-based international order, and the other is the American security commitment. Whether we like to admit it or not, it's the two blocks to keep the world functioning in the past 70 years. But now we are really in a challenging time. As I said, somebody say now is started the Cold War II. Maybe it's not a Cold War II, but it's definitely a competition between democracy and autocracy. And before the COVID, and you can hear, even here in Germany, a lot of advocates for this autocratic government's model. They think it's more efficient. They can build transfer rapid in 2 years. They can, or they can provide this infrastructures funds in such huge size. But after COVID, actually, we have understand one thing: democracy maybe sometimes thinks it's not that efficient, but it actually provided a substantial solution for our next generation. Because if the whole resources is unlimited, then an autocratic government system would be more efficient. But unfortunately, the resource in this earth is not unlimited. We need to discuss. We need to have an innovative solution for our future to solve the energy scarcity, to solve the climate change. It's not, and such innovative solution won't be provided by an autocratic system. And it's also, I mentioned that why semiconductor is our silicon shield against autocracy, because it's an industry what is built on this international order, built on this innovative spirit. So that's why I think the experience of Taiwan during the past 30 years maybe can provide an answer for this systemic competition. Thank you. Yeah. Mm-hmm.
Yeah, thank you so much for your great presentation. I feel more like a moderator of the discussion now, because it's all about Taiwan, and it's about the situation in Taiwan. And the only reason that I'm here is that Barbara Mittler kindly called me or emailed to me to ask whether I would participate in this event. And just by chance, at the time when I received your email, I was in Taiwan teaching German constitutional law, an introduction to German constitutional law, to students of National Taiwan University. And I've done that for 4 times now, so that's just to briefly introduce myself and to tell you why I am here at all as a German law professor. So I have some little experience and insight into the system and into Taiwanese constitutional law and life. And so I would like to just add a very few impressions and remarks in order to then start the discussion. Just a few remarks on the legal architecture, the legal order, the system, and then one remark on the American securities guarantees. So first of all, I am just absolutely impressed how successful Taiwanese constitutional law became over time based on the Weimar Constitution model. And that's just astonishing. And one explanation might be, or that's just one thought that I have, is that in the Weimar Constitution, the president has a very strong role, and at the same time, the Constitution is quite open with regard to fundamental rights, with regard to social rights, and with regard to the development of the society. So could it be, that's more like a question to you, that the Weimar Constitution was so suitable as a model because it provided for a strong president, Chiang Kai-shek, going from a dynasty to a democracy. Actually, it was the same situation in Germany, going from a monarchy to a democracy, similar situation. So providing for a strong president, providing for the possibility of emergency rights, providing for the president overruling what parliament does. So could it be that that was particularly suitable for Taiwan in the 1950s, 60s, 70s, slowly going towards a more democratic system? So that's an impression I have. And then at the same time, this Weimar model is open to more fundamental rights, is open to social rights, and these rights then developed over time in Taiwan. And I'm also impressed that that happened because it's not obvious from my point of view that a society in Asia, against the background of Asian culture, develops individual liberal rights to such an extent, which now goes further than Germany in some ways, recognizing same-sex marriage as a constitutional right, which Germany has not done yet in the same way. So now we learned that this is maybe also due to some pressure, due to the fact that this might have been the only way ahead for Taiwan. So that might be an explanation for this development of fundamental rights. But it is impressive to see how liberal Taiwan is nowadays, based on these fundamental rights, again, on the basis of the model of the Weimar Constitution. Despite the language barrier, and my impression is that when I talk to the Taiwanese students, they are absolutely capable of communicating about these concepts in Chinese, and maybe language in Chinese language has developed in a way in order to take account of these Western legal concepts. So I had the impression that there was no problem in understanding at all. Looking at constitutional law in Taiwan and its development over time today, I even have the impression that in some ways German constitutional law can now learn from Taiwan as well, and from Taiwanese legal concepts. For example, looking, that's a little technical, but it is interesting, I think, looking at the standards of scrutiny when applying constitutional guarantees, we just apply the proportionality test. We've just done that in class 2 hours ago. applying the constitutionality test, the proportionality test, whereas in Taiwan you use different standards of scrutiny, intermediate standard of scrutiny, strict standard of scrutiny, and so on, depending on which case it is. And that's an influence, I think, of US constitutional law, which then could become a model for developing German constitutional law as well. I already talked about same-sex marriage and the fact that Taiwan is further ahead than Germany in this regard. And also, I think Germany can nowadays learn from Taiwan, looking at the openness of the Taiwanese Constitutional Court with regards to other systems, with regard to comparative constitutional law, with regards to drawing from other sources. And I think that could be nowadays a good example for Germany as well. A last point on this question of the legal concept and the legal order, and that's important to me. I think that when we look at the development over time, the most important factor are persons. Persons who take a look at other countries, at other legal systems, other cultures, persons who develop personal relationships with each other, persons who fill exchange agreements, partnership agreements with life. That's, I think, how all of this comes about, and how such a transfer, such legal transfer of ideas really happens. It's about persons, and it all begins with the author, more or less, if I understand correctly, of the Taiwanese constitution in 1947, drawing from the Weimar Constitution, who was a student in the 1920s in Berlin, yes, studying politics and law in Berlin in the 1920s, and then taking these ideas to Taiwan and very much influencing the Constitution of the Republic of China in 1947. And I think that's a very good example that shows us the importance of this exchange until today. So when we have our exchange agreements today, and we have Taiwanese students here, we have German students in Taiwan, I think that's what we always have to think about, that these are the people who will develop the law in the future, and who are the resource and the factors that make this legal exchange and a transfer of ideas practical. So I think that's very important. So it is an impressive development, and it came into being on the basis of people who took ideas and who are in exchange with each other. And then just one brief remark on the public international law situation, and that relates to the question of the securities guarantees. It is a very difficult situation looking at it from the point of view of public international law, and I think it's very convincing what you're saying. I think what we really have to take account of from the point of view of public international law is that there is a path dependency. It's not the situation of a province just saying we don't want to be part of a country anymore from one day to another. It's the development of decades. And there were a lot of negotiations between the different parties. There was the Taiwan Relations Act, there were the memoranda, there was the fact, and there is the fact, that the US provides weapons to Taiwan without the People's Republic of China effectively being able to prohibit this. So all of these are facts, and we have to take account of this in public international law. So it is not that easy, and against this background, I think it would be a problem for public international law if China invaded and used violence. It's not the same situation as the situation of a province who just says we don't want to be part of another country from one day to another day. And it does bring, or it does remind me of a concept that has been developed here in Heidelberg, a concept developed by Jochen Frohwein, the former director of the Max Planck Institute for Public International Law here in Heidelberg. And he developed the idea of the de facto regime. So whether or not Taiwan can be considered to be a state or not, maybe not, yeah, due to the missing recognition from a sufficient number of other states, but it is a de facto regime. And it's, so a de facto regime might be able to, or might have to be seen in another perspective than some kind of province. Maybe that's all for now. And now I'm looking forward to our discussion.
Yeah, maybe we can open up the floor for questions.
If in 1946, right, they're using the Weimar Constitution of all constitutions at that point in time, and then this constitution, because the president is so strong, right, can be used to implement military law, basically state, for 40 years.
Yes.
Why is it that when they were doing the reforms of the constitution, they didn't just throw it out of the window and use another one? I really don't understand that, right? Because they did change a lot.
Yeah.
But this constitution, in a way, is sullied, isn't it, by the fact that it was used to impose military law for such a long time.
Yeah. And we should understand, back to 1946, the Kuomintang was an autocratic regime. And this constitution actually is a compromise. And before that, Kuomintang was preferred to another model, to have a presidential model and to have a long power in the government. But with this Weimar Constitution, at least it have separated the right from the president and the executive yuan, is the cabinet. So for this kind of a compromise was that time that for the founding father of the Constitution have hoped to prevent such a dictatorship. But unfortunately, it came the civil war. And actually, this constitution has never been really enacted in China. It was only used as an instrument to elect the president and the member of the legislative yuan. And actually, the whole guarantee of the basic right have never been realized during this time. So that's why even from my point of view, I don't think it was really enacted back then. And then in 1987, maybe it's the first time it's truly enacted in Taiwan. And through this model and through this adoption of modern German basic laws, etc., to develop instrument to guarantee the freedom and basic rights in Taiwan. So actually, as mentioned, that times the founding father of the Constitution has really studied in 1920s in Berlin. His name is Zhang Junmai. Actually, he is not from Communist Party or neither nor Communist Party as a kind of third parties that time. So was entrusted with this task to develop the whole constitution. Yeah.
Maybe, if I may add, I would say the Weimar Constitution is very flexible. It allows for a very strict regime,
yes,
with a strong president, but at the same, and it was detrimental in Germany. But it also allows for development of democracy, and Germany didn't have the chance to use it as in this way. But it allows for democracy. It allows for the development of basic rights to more extensive, in a more extensive way, and so it was flexible enough to take account of the developments that then happened and to really strengthen the rights side.
Yeah, I was also flabbergasted by the Weimar Republic being upheld as a model. When I wrote my master thesis on the demise of the Weimar Republic about 40 years ago, one of the factors that contributed to its demise that was often discussed among historians, obviously, was the Weimar Constitution, and particularly the fateful role of the president and the inherent tensions between the so-called dictatorial powers of the president and the parliamentary system. But I just wonder whether it's primarily about the individuals that occupy the positions of power, because in the Weimar Republic in 1923, President Ebert defended the republic by emergency decree. But nevertheless, I think it is just flabbergasting that the Weimar Republic was the Weimar Constitution was adopted at the same time, or upheld as a model at the same time when in Germany, West Germany, the constitutional deliberations took it as a negative foil. I'm just wondering if there were other parts of, the Weimar Republic, the Weimar Constitution had other parts. For example, popular referenda.
Yeah.
Did that play a role
yes.
in
Yes.
in the Taiwanese debates?
Yes, correct. And one fact I like to add is that maybe Taiwan's the only place have celebrated the 100 years Weimar Constitution. So in 2019, the Taiwan Association for Philosophy of Law and Social Philosophy, IVR Taiwan section, has celebrated the Weimar Republic in jurisprudence, legal philosophy, and political philosophy of the Weimar Constitution 100 years after its adoption. Yeah, and it's a big symposium in Taipei, discuss about the heritage we have from this Weimar Constitution and from legal philosophy and others state theories aspects. And actually, this popular referendum plays an immense role in Taiwan. But we have struggled with this referendum model. But we have to say that it has resolved some very crucial issues in Taiwan. As we have mentioned, the legalization of the same-sex marriage in Taiwan is through the referendum. First, through a decision of a constitutional court, and for the parliament is too difficult to decide it, which model we should use to legalize the same-sex marriage. Then have this referendum. And it's really a crucial issue, has splitted the family, the religion in Taiwan back then and 2019. Even there's President Chai has almost costed his chance to be elected again because of this issue, because it's so controversial for our tradition. And only through the referendum, it's in a small margin, then we have decided now we have to legalize the same-sex marriage outside the civil code, to have a special law to legalize it. So for some extent, it's not the same meaning like the marriage according to civil code. It's a marriage according to a special code. And through this referendum, then we have find this compromise solution. So it did play a really important role, but it also be used as some kind of a political campaign. So now it's limited only once in 2 years to have a popular referendum in order to save this public social debate in every crucial issue, because it's really too exhausting the whole social resources. Yeah.
In Germany, if I may add, in Germany, on the level of the federation, we are very strict, and we do not have a public referenda at all. And I wonder whether, on this issue, for example, same-sex marriage and a constitutional guarantee, this might have been useful as well, instead of the parliamentary process that we then actually had. But we have the same result, more or less, in the area of parliamentary law, but not in constitutional law. And the constitutional law question is still kind of open in Germany. If I may just add one point that seems interesting to me in Heidelberg in particular, it's not only the Weimar Constitution, which we also celebrated to some extent in 2019 in Germany, or we discussed about it. But it's not only the Weimar Constitution, it's also other historical relationships between Germany and China, the Republic of China in the past, in the area of constitutional law that are part of the development. And one interesting aspect is that Blunschli, a constitutional law professor in Heidelberg, he was originally from Switzerland, and at some point of time in the 1860s, 1870s, he taught in Heidelberg, and he took influence on the development as well. And one of his pupils, he was Japanese, and he translated his Deutsche Staatslehre into Chinese. And if I'm correct, this was also part of the development of a constitutional law then in the Republic of China, and part of the development of this constitutional law thinking. A professor who taught in Heidelberg, and long before the Weimar Constitution, and also others until Carl Schmitt and others who are very influential until now in Taiwan. And that's also part of the story, not only the Weimar Constitution itself.
Correct. Yes.
No?
We had 2 questions from professors. I'm sure that students will have questions as well.
So the CCP is pressuring a lot of countries in the global south to cut relations with Taiwan and economic and diplomatic relations. So what would you recommend to the Western countries to stop this, or maybe sign a new agreement, or
is really difficult question, but what we wish is that the Western can recognize what is actually behind the scene. It's what I'm trying to emphasize is really about the systemic competition. If we understand this point of view, and we even that in Taiwan we are also discussing how we have to handle with the co-state relations. But one point is that from our experience, we think the Western should really stand together to defend this rules-based international order, and what it shows in the last years Ukraine war, what the democracies has really shown its solidarity to the Ukraine, and it's the best way for Taiwan actually to give us the courage, to give us the hope that even a small country can really defend itself, with the aid from the democratic allies.
Questions?
So I share the initial irritation about the Weimar Constitution as an example, but I'd like to raise a question about the surroundings of that constitution and practice. I don't want to be understood as a belated offender of the German Sonderweg, but it was not only a constitution, but structural economic and political conflicts within Germany that made that state fail. And maybe you have some ideas what internal and external structural reasons within the Republic of China made this contribution survive and strive.
Actually, I should say that our legal system, the German legal culture is the fundamental one. But we also adopted the Japanese, the Americans, and the UK's. And you can see our law professors, they have a German degree, American degree, UK degree, the US degree, etc. And these mixtures make our legal culture have more adapted to some new ideas, like protections of business secrecy, what is immense important for developing our industry. So in this point of view, I think this intercultural exchange is very important, even for German legal system. Have to, like I mentioned, the legal culture should be also an open innovation. That means open to all kind of cultural thinking, even to Muslim world and also etc. I think German legal theorists can really provide something, because we have the great belief about the theoretical ability in Germany. Yeah.
If I may add, I think your question very well shows to what extent the success of a constitution depends on the environment, on the political environment, the societal environment. And we have experts here in the room who can tell us everything about what happened in the Weimar times in Germany and why the constitution eventually failed. So it's not the wording of the constitution as such, and only it's also how it was applied, and it was applied in a different way and used in a different way in the Republic of China and on Taiwan at that time. And so it became successful, and then I think your answer relates to the more recent times when when this intercultural exchange became more and more important, and when the Constitution has been and still is so successful because ideas are not only drawn from nowadays German constitutional law, but also from American constitutional law and so on. And so answers can be given that cannot be given on the basis of a constitution, of your constitution, that cannot be given on the basis of the German constitution, because we essentially only look at our own legal culture. And that's why I initially said we can learn from Taiwan in this respect today, because Taiwan is so open to intercultural exchange and to different standards of scrutiny and so on, which we are not. And so that's the strength of the Taiwanese constitution today, I would say. But as a whole, on the whole, it's just the whole environment in which a constitution becomes effective.
Before I pass on the mic to Barbara Mittler for a final word or a question or both, I would like to squeeze in a question myself. Both of you defended, with the help of legal concepts, the independency of Taiwan tonight, to a certain degree or not. Maybe I misunderstood you. But if you want to turn it around, and I'm not sure it's a fair question of mine, but if you want to turn it around and if you want to look at these legal issues from a typical mainland perspective, what would be the typical arguments against the arguments that you used? First question. And second question, what are all, and also a little bit provocative, what are all these legal concepts worth in an era of a Ukraine war?
Yeah, and maybe as Professor Kube has mentioned, there's a concept developed by Professor Forwein's de facto regime, and there are also another consensus amongst the international legal experts. It would say that Taiwan is a sua generis entity. And sua generis actually is a Latin concept. I cannot translate that well in German.
Of its own kind.
Yes, one of kind. Yes.
Of its own kind.
And in Munich, I find the explanation is mia san mia. So actually, it's not that bad as for Taiwan to be the only kind in this planet. Yeah. So maybe you could avoid the conflict, and it's and in the end, we believe on a peaceful solution, and we believe on there's on the legend or illusion of democracy. That's why the only survival strategy for Taiwan, actually. Yeah.
I talked about a path dependency in the beginning. So independence is a difficult, problematic word, maybe, and it is a controversial situation, and there are arguments put forward from the other side, arguments based on the fact that there was the Qing dynasty in the 18th and until 1895 on Taiwan, which is not the People's Republics of China, but it was the Qing dynasty there. So it is controversial. But I absolutely agree that there is a path dependency. We have to see the development over time. We have to see the Taiwan Relations Act. We have to see the weapons provided to Taiwan by the U.S., not with the consent of the People's Republic, but it happened, and it's still happening. So it would be a different kind of intervention into Taiwanese affairs if China invaded, and it's a different thing from any kind of province, as I said. So we have to see this whole picture, and you say it's sui generis. This is a sui generis situation, and it has to be dealt with accordingly. It's a complicated situation, and the People's Republic of China will have to take account of this, I would say. And if you're asking about violence, you're asking about Ukraine, but if we stop believing in the power of the law and in the idea of legal relations, then it's all violence. Yeah.
It's interesting. You gave half of an answer to a question that I haven't yet asked, but just two things I found very interesting now. One thing was said that a constitution is always set into a setting of social situation, labor situation, what have you. And you said, the other thing you said was that you are impressed with the theoretical capability of Germans. We are usually impressed with the capability of patience of the Chinese. So you were hinting at one point before, you were saying that had Ukraine not been able to defend itself now with the help of the international community, then the situation for you might have been much more dangerous. So my question, and I was at the time, I saw two people having two pet projects, Mr. Putin, Ukraine, and Xi Jinping, Taiwan. How long do you think the shock of Mr. Xi Jinping will last of what happened now? Because I think what he thinks now is a window has closed for him. That's my view at the moment. But how do you think this actual situation will stay on in case there is a decision the one or the other way in the Ukraine?
Sure. And of course, there are some opinions saying that the other window for President Xi would be January 2025, when the Americans in his presidential elections chaos, which happens a few years ago, it could be happen again, and it would be another window for President Xi. So that's why we think we have, in Taiwan, we sense this urgency. So don't think that according to the happiness index, Taiwan ranks 26 in the world. It's not means that we are not worried about the war. And there are a lot of civil society's initiative to provide the civil society how to defend itself, to train themselves for the first aid. And even in Taiwan have developed an app. You can find a bunker by an invasion close to you. So let's not that we are not preparing for that, and we believe that it's the best way to hinder such adventurous thinking of an autocratic regime. But as everybody now read in the media, the risk is still there, and we should prepare for that.
Okay, I have a question for each of you. First of all, for the German perspective on a different kind of encounter, also related to the Weimar Constitution, but to mainland China, because they recently have rediscovered Carl Schmitt, who did the ideology of law for the Third Reich, and developed an ideology of law for mainland China out of that. And my question would be, how much would you have to misread Carl Schmitt to make it into a kind of functional concept for China and still claim it respects the law? And secondly, relating to the Taiwan Constitution, there is one clause, at least 2 years ago, there was one clause that says this should apply to the whole of China, including mainland China. And there's some notion of reconquering mainland China. And my question would be, why is it still there? And are people talking about it, or is it just some relic of old times? Yeah, thank you.
Yes, should I just answer
sure.
to Carl Schmitt? Well, if I see it correctly, and from my discussions with colleagues in Taiwan, Carl Schmitt is also popular in Taiwan, and he's being read because he deals with problems, and he has perspective that we do not have anymore, maybe, and that's this enemy situation. Of course, he is highly controversial, but as I see it, it's not only in mainland China, but also in Taiwan that Carl Schmitt is being read and popular, and so it always depends on what you make of a legal theory in the end. Of course, he was an advocate and he was used by the Nazis. Maybe it's not necessarily the result when you read Carl Schmitt that you end up with this kind of political order, but of course he is highly problematic and controversial. Just saying, it's not only in mainland China, it's also in Taiwan that he's being read and liked, but others as well, including Bluntschli. So maybe that's all I can say about Carl Schmitt at this point.
Yeah, and the clause you mentioned has different interpretations actually, and actually in those constitutions in Taiwan is stipulated that we have to respect the international conventions and treaties, and that means we should respect the status the People's Republic of China has become to as a member of the Security Council in the UN. We have to respect there's international treaties which PRC signed with other countries, and also our constitution stipulated our territory was defined by the effectiveness. In Chinese, it's always misreadings because it has 固有. 固 has effectively owned, but for many Chinese, they were saying this 固 is we have from 1,000 years. So that's why this imperial thinking in Taiwan, because of this misunderstanding of this Chinese word. And this means actually what you effectively owned by now, not for 70 years ago. So that's according to our constitution, actually it has already provide this interpretation that Taiwan is as it is now. And it's also provide a legal basis for Taiwan to join the international organizations such as World Trade Organizations, etc. So that's why the only way for us is to integrate it to this international order and to protect this international order and not to be changed by the revisionists, such as Russian or Chinese.
I'm afraid we are running out of time, but we still have two questions, one there and one there, and I would recommend that we collect these two questions at the end of this session.
Okay, thank you. I just wanted to ask, I understand that one of the extraordinary aspects of the Taiwanese constitution is that there are actually 5 instead of the usual 3 branches of government. Do you think that that is something that is an advantage for the constitution Okay, I can already see an degree. And I was going to ask, do you think that is something that other countries can learn from? But I can already see that that's not true.
I wanted to ask something completely different beside of the constitutional law, but rather about the conflict you mentioned between authoritarianism and democracy. And you mentioned one major argument actually for authoritarianism, which is the fast decision making, which of course is, as we know, very superficial argument, as the results are quite superficial. They are well. It might look at the outside as efficiency, but it is a less reliable form. However, the fast decision-making of those authoritarian regimes, it seems to be intriguing to a lot of people in business. And you also mentioned that this situation is kind of a Cold War II, and actually in the Cold War I, we kind of had a response to this fast decision-making for authoritarianism, which was, in fact, that democracies have a promise of economic prosperity for a large sum of individuals, because both labor and innovation are compensated fairly and to the benefit of those people who work hard. So the promise of economic prosperity and actually gathering of individual wealth had been an argument in Cold War I. And my question would be now, in this Cold War II era, is this still an argument? Do we have to change or amend those values, or maybe don't uphold these values anymore? And what is the Taiwanese perspective on this? And are we, like as the Western democracies, upholding the values that come out of democracy to deliver arguments to the democratic regimes? Because for some reason, the arguments for authoritarian regimes, they pop into mind much faster than the ones for democratic regimes.
Yeah, I don't like to call it Cold War II, but if we use these terms, I mean in the Cold War II, fully our international society should add one dimension is about the social rights. What is totally not totally a failure for this economic prosperity? It's also the failure why these autocratic regimes, they have gathered their strengths in the past 30 years, because in the Cold War I, this social dimension is maybe it's not that emphasized. So it's create this environment for the autocratic regimes. They have like China, they can to announce their legitimacy by elimination of the poverty, etc. Because in many Western countries, especially in one big Western country, have no effective health insurance, etc. And it provides this instability for the democratic world. So that's why I think that's what we learned from this German model. We have really installed there's universal health insurance in our system. Is one of the major factors why our democracy functioning. Yeah.
Mm-hmm. Maybe I think that's a very important question, because the Western democracies, they will have to develop too, and they will have to evolve in order to be able to be effective rivals to the authoritarian regimes. And the social dimension is one aspect, social democracy, social welfare democracy, as also the ecology and other aspects that we'll have to take account of. But still, I think we will have to rely on these values of democracy and freedom if we want to have a chance against the authoritarian regimes. And maybe in particular, you mentioned the US, in Europe, with the European Union and the values that European Union fosters in Article 2 of the EU treaty, I think that's our chance for the future, based on democracy, based on social rights, and also based on an answer to the questions of ecology and so on. And still, and even more so, I would say that we should rely on the law and legal certainty, because the authoritarian regimes, when you have a business and you go to China and Russia, you may have some kind of efficiency on the surface, but you never know whether or not you will your business will be confiscated. And this will not take place in the European Union or in Taiwan. So I think we will have to stress that and emphasize that as our advantage that we might have in comparison.
Well, in the name of the Heidelberg University and the HCA and the CATS, I would like to thank you for a very thought-provoking conversation. Thank you.
Thank you.